Welcome back. We're up to episode 18 of the Mueller Report audiobook. We're in volume 2, part 4. We're looking at the various potential efforts of obstruction of justice. The one we're looking at today is the President's efforts to curtail the special counsel investigation. 2 days after the President directed McGahn to have the special counsel removed, the President made another attempt to affect the course of the Russia investigation. On June 19, 2017, the President met one-on-one with Corey Lewandowski in the Oval Office and dictated a message to be delivered to Attorney General Sessions that would have had the effect of limiting the Russia investigation to future election interference only. 1 month later, the President met again with Lewandowski and followed up on the request to have Sessions limit the scope of the Russia investigation. Lewandowski told the President the message would be delivered soon. Hours later, the President publicly criticised Sessions in an unplanned press interview, raising questions about Sessions' job security. The President asked Corey Lewandowski to deliver a message to Sessions to curtail the special counsel investigation. On June 19, 2017, 2 days after the President directed McGahn to have the special counsel removed, the President met one-on-one in the Oval Office with his former campaign manager, Corey Lewandowski. Senior White House advisors described Lewandowski as a devotee of the President and said the relationship between the President and Lewandowski was close. During the June 19 meeting, Lewandowski recalled that after some small talk, the President brought up Sessions, criticised his recusal from the Russia investigation. The President told Lewandowski that Sessions was weak and that if the President had known about the likelihood of recusal in advance, he would not have appointed Sessions. The President then asked Lewandowski to deliver a message to Sessions and said, "Write this down." This was the first time the President had asked Lewandowski to take dictation, and Lewandowski wrote as fast as possible to make sure he captured the content correctly. The President directed Sessions should give a speech publicly announcing, "I know that I recuse myself from certain things having to do with specific areas, but our POTUS is being treated unfairly, very unfairly. He shouldn't have a special prosecutor counsel because he hasn't done anything wrong. I was on the campaign with him for 9 months. There were no Russians involved with him. I know it for a fact because I was there. He didn't do anything wrong except he ran the greatest campaign in American history." The dictated message went on to state that Sessions would meet with the special counsel to limit his jurisdiction to future election interference. "Now, a group of people want to subvert the Constitution of the United States. I'm going to meet with a special prosecutor to explain this is very unfair and let the special prosecutor move forward with investigating election meddling for future elections so that nothing can happen in future elections." The President said that if Sessions delivered that statement, he would be the most popular guy in the country. Lewandowski told the President he understood that what the President wanted Sessions to do. Lewandowski wanted to pass the message to Sessions in person rather than over the phone. He did not want to meet at the Department of Justice because he did not want a public log of his visit and did not want Sessions to have an advantage over him by meeting on what Lewandowski described as Sessions' turf. Lewandowski called Sessions and arranged a meeting for the following evening at Lewandowski's office, but Sessions had to cancel due to a last-minute conflict. Shortly thereafter, Lewandowski left Washington, D.C. without having had an opportunity to meet with Sessions to convey the President's message. Lewandowski stored the notes in a safe at his home, which he stated was his standard procedure for sensitive items. The President follows up with Lewandowski. Following his June meeting with the President, Lewandowski contacted Rick Dearborn, then a senior White House official, and asked if Dearborn could pass a message to Sessions. Dearborn agreed without knowing what the message was, and Lewandowski later confirmed that Dearborn would meet with Sessions for dinner in late July and could deliver the message then. Lewandowski recalled thinking that the President had asked him to pass a message because the President knew Lewandowski could be trusted, but Lewandowski believed Dearborn would be a better messenger because he had a long-standing relationship with Sessions because Dearborn was in the government while Lewandowski was not. On July 19, 2017, the President again met with Lewandowski alone in the Oval Office. In the preceding days, as described in Volume 2, Section 2, emails and other information about the June 9, 2016 meeting between several Russians and Donald Trump Jr. Jared Kushner and Paul Manafort had been publicly disguised. In the July 19 meeting with Lewandowski, the President raised his previous request and asked if Lewandowski had talked to Sessions. Lewandowski told the President that the message would be delivered soon. Lewandowski recalled that the President told him that if Sessions did not meet with him, Lewandowski should tell Sessions he was fired. Immediately following the meeting with the President, Lewandowski saw Dearborn in the anteroom outside the Oval Office and gave him a typewritten version of the message the President had dictated to be delivered to Sessions. Lewandowski told Dearborn that the notes were the message they had discussed, but Dearborn did not recall whether Lewandowski said the message was from the President. The message definitely raised an eyebrow for Dearborn, and he recalled not wanting to ask where it came from or think further about doing anything with it. Dearborn also said that being asked to serve as a messenger to Sessions made him uncomfortable. He recalled later telling Lewandowski that he had handled the situation, but he did not actually follow through with delivering the message to Sessions, and he did not keep a copy of the typewritten notes Lewandowski had given him. The President publicly criticised Sessions in a New York Times interview. Within hours of the President's meeting with Lewandowski on July 19, 2017, the President gave an unplanned interview to the New York Times in which he criticised Sessions' decision to recuse from the Russia investigation. The President said that Sessions should have never recused himself, and if he was going to recuse himself, he should have told me before he took the job and I would have picked somebody else. Sessions' recusal, the President said, was very unfair to the President. How do you take a job and then recuse yourself? If he would have recused himself before the job, I would have said, thanks, Jeff, but I can't, I'm not going to take you. It's extremely unfair, and that's a mild word to the President. Hicks, who was present for the interview, recalled trying to throw herself between the reporters and the President to stop parts of the interview, but the President loved the interview. Later that day, Lewandowski met with Hicks and they discussed the President's New York Times interview. Lewandowski recalled telling Hicks about the President's request that he meet with Sessions and joking with her about the idea of firing Sessions as a private citizen if Sessions would not meet with him. As Hicks remembered the conversation, Lewandowski told her the President had recently asked him to meet with Sessions and deliver a message that he needed to do the right thing and resign. While Hicks and Lewandowski were together, the President called Hicks and told her he was happy with how coverage of his New York Times interview criticising Sessions was playing out. The President orders Priebus to demand Sessions' resignation. 3 days later, on July 21, 2017, the Washington Post reported that US intelligence intercepts showed that Sessions had discussed campaign-related matters with the Russian ambassador, contrary to what Sessions had said publicly. That evening, Priebus called Hunt to talk about whether Sessions might be fired or might resign. Priebus had previously talked to Hunt, and when the media had reported on tensions between the President would have to fire Sessions if he wanted to remove Sessions because Sessions was not going to quit. According to Hunt, who took contemporaneous notes of the July 21 call, Hunt told Priebus that, as they had previously discussed, Sessions had no intention of resigning. Hunt asked Priebus what the President would accomplish by firing Sessions, pointing out there was an investigation before and there would be an investigation after. Early the following morning, July 22, 2017, the President tweeted, "A new intelligence leak from the Amazon Washington Post, this time against AG Jeff Sessions. These illegal leaks, like Comey's, must stop." Approximately 1 hour later, the President tweeted, "So many people are asking why isn't the AG or special counsel looking at the many Hillary Clinton or Comey crimes, 33,000 emails deleted." Later that morning, while aboard Marine One on the way to Norfolk, Virginia, the President told Priebus that he had to get Sessions to resign immediately. The President said that the country had lost confidence in Sessions and the negative publicity was not tolerable. According to contemporaneous notes taken by Priebus, the President told Priebus to say that he needed a letter of resignation on his desk immediately, and that Sessions had no choice but must immediately resign. Priebus replied that if they fired Sessions, they would never get a new Attorney General confirmed and that the Department of Justice and Congress would turn their backs on the President. But the President suggested he could make a recess appointment to replace Sessions. Priebus believed that the President's request was a problem, so he called McGann and asked for advice, explaining that he did not want to pull the trigger on something that was all wrong. Although the President tied his desire for Sessions to resign to Sessions' negative press and poor performance in congressional testimony, Priebus believed that the President's desire to replace Sessions was driven by the President's hatred of Sessions' recusal from the Russia investigation. McGann told Priebus not to follow the President's order and said they should consult their personal counsel, with whom they had attorney-client privilege. McGann and Priebus discussed the possibility that they would both have to resign rather than carry out the President's order to fire Sessions. That afternoon, the President followed up with Priebus about demanding Sessions' resignation using words to the effect, "Did you get it? Are you working on it?" Priebus said he believed that his job depended on whether he followed the order to remove Sessions, although the President did not directly say so. Even though Priebus did not intend to carry out the President's directive, he told the President he would get Sessions to resign. Later in the day, Priebus called the President and explained that it would be a calamity if Sessions resigned because Priebus expected that Rosenstein and Associate Attorney General Rachel Brand would also resign, and the President would be unable to get anyone else confirmed. The President agreed to hold off on demanding Sessions' resignation until after the Sunday shows the next day to prevent the shows from focusing on the firing. By the end of that weekend, Priebus recalled that the President relented and agreed not to ask Sessions to resign. After the next several days, the President tweeted about Sessions. On the morning of Monday, July 24, 2017, the President criticised Sessions for neglecting to investigate Clinton and called him beleaguered. Pardon me. On July 25, the President tweeted, "Attorney General Jeff Sessions has taken a very weak position on the Hillary Clinton crimes. Where are emails and DNC server and Intel leakers?" The following day, July 26, the President tweeted, "Why didn't Attorney General Sessions replace acting FBI Director Andrew McCabe, a Comey friend, who was in charge of Clinton investigation?" According to Hunt, in light of the President's frequent public attacks, Sessions prepared another resignation letter and for the rest of the year carried it with him in his pocket every time he went to the White House. In analysing the President's efforts, so we'll move on to the analysis now. In analysing the President's efforts to have Lewandowski deliver a message directing Sessions to publicly announce that the special counsel investigation would be confined to future election interference, the following evidence is relevant to the elements of obstruction of justice. So we look at obstructive act, nexus to the proceeding, and intent. So the obstructive act, the President's effort to send Sessions a message through Lewandowski would qualify as an obstructive act if it would naturally obstruct the investigation and any grand jury proceedings that might flow from the inquiry. The President sought to have Sessions announce that the President shouldn't have a special prosecutor counsel and that Sessions was going to meet with the special prosecutor to explain this as very unfair and let the special prosecutor move forward with investigating election meddling for future elections so that nothing can happen in future elections. The President wanted Sessions to disregard his recusal from the investigation, which had followed from a formal DOJ ethics review, and have Sessions declare that he knew for a fact that there were no Russians involved with the campaign because he was there. The President further directed that Sessions should explain that the President should not be subject to an investigation because he hasn't done anything wrong. Taken together, the President's directives indicate that Sessions was being instructed to tell the special counsel to end the existing investigation into the President and his campaign, and with the special counsel being permitted to move forward from the investigating election meddling for future elections. Nexus to official proceeding. As described above, by the time the President's initial one-on-one meeting with Lewandowski on June 19, 2017, the existence of a grand jury investigation supervised by the special counsel was public knowledge. By the time of the President's follow-up meeting with Lewandowski, we've got a redaction there of the rest of that sentence. To satisfy the nexus requirement, it would be necessary to show that limiting the special counsel's investigation would have the natural and probable effect of impeding the grand jury proceeding. Intent. Substantial evidence indicates that the President's efforts to have Sessions limit the scope of the Special Counsel's investigation to future election interference was intended to prevent further investigative scrutiny of the President and his campaign's conduct. As previously described in Volume 2, Section 2b, the President knew that the Russia investigation was focused in part on his campaign, and he perceived allegations of Russian interference to cast doubt on the legitimacy of his election. The President further knew that the investigation had broadened to include his own conduct and whether he had obstructed justice. Those investigations would not proceed if the Special Counsel's jurisdiction were limited to future election interference only. The timing and circumstances of the President's actions support the conclusion that he sought that result. The President's initial direction that Sessions should limit the Special Counsel's investigation came just 2 days after the President had ordered McGahn to have the Special Counsel removed, which itself followed public reports that the President was personally under investigation for obstruction of justice. The sequence of those events raises an inference that after seeking to terminate the Special Counsel, the President sought to exclude his and his campaign's conduct from the investigation scope. The President raised the matter to Lewandowski again on July 19, 2017, just days after emails and information about the June 9, 2016 meeting between Russians and senior campaign officials had been publicly disclosed, generating substantial media coverage and investigative interest. The manner in which the President acted provides additional evidence of his intent. Rather than rely on official channels, the President met with Lewandowski alone in the Oval Office. The President selected a loyal devotee outside the White House to deliver the message, supporting an inference that he was working outside White House channels, including McGahn, who had previously resisted contacting the Department of Justice about the Special Counsel. The President also did not contact the Acting Attorney General, who had just testified publicly that there was no cause to remove the Special Counsel. Instead, the President tried to use Sessions to restrict and redirect the Special Counsel's investigation when Sessions was recused and could not properly take any action on it. On July 19, 2017, events provide further evidence of the President's intent. The President followed up with Lewandowski on separate one-on-one meetings one month after he first dictated the message to Sessions, demonstrating he still sought to pursue the request. And just hours after Lewandowski assured the President that the message would soon be delivered to Sessions, the President gave an unplanned interview to the New York Times in which he publicly attacked Sessions and raised questions about his job security. 4 days later, on July 22, 2017, the President directed Priebus to obtain Sessions' resignation. That evidence could raise an inference that the President wanted Sessions to realise that his job might be on the line as he evaluated whether to comply with the President's direction, that Sessions publicly announced that, notwithstanding his recusal, he was going to confine the Special Counsel's investigation to future election interference. So that's the end of that one. The next one we're moving on to is the President's efforts to prevent disclosure of emails about the June 9, 2016 meeting between Russians and senior campaign officials. So an overview of that is, by June 2017, the President became aware of emails setting up the June 9, 2016 meeting between senior campaign officials and Russians who offered derogatory information on Hillary Clinton as part of Russia and its government's support for Mr. Trump. On multiple occasions in late June and early 2017, the President directed aides not to publicly disclose the emails, and he then dictated a statement about the meeting to be issued by Donald Trump Jr. describing the meeting as about adoption. Evidence for this one. The President learns about the existence of emails concerning the June 9, 2016 Trump Tower meeting in mid-June 2017. The same week, the President first asked Lewandowski to pass a message to Sessions. Senior administration officials became aware of emails exchanged during the campaign, arranging a meeting between Donald Trump Jr., Paul Manafort, Jared Kushner, and a Russian attorney. As described in Volume 1, Section 4A.5, the email stated that the Crown Prosecutor of Russia had offered to provide the Trump campaign with some official documents and information that would incriminate Hillary and her dealings with Russia, as part of Russia and its government's support for Mr. Trump. Trump Jr. responded, "If it's what you say, I love it." and he, Kushner, Manafort, met with the Russian attorney and several other Russian individuals at Trump Tower on June 9, 2016. At the meeting, the Russian attorney claimed the funds derived from illegal activities in Russia were provided to Hillary Clinton and other Democrats, and the Russian attorney then spoke about the Magnitsky Act, a 2012 US statute that imposed financial and travel sanctions on Russian officials, and that had resulted in a retaliatory ban in Russia on US adoptions of Russian children. According to written answers submitted by the President in response to questions from this office, the President had no recollection of learning of the meeting or the emails setting it up at the time the meeting occurred or at any other time before the election. The Trump campaign had previously received a document request from SSCI that called for the production of various information, including a list and description of all meetings between any individual affiliated with the Trump campaign and any individual formally or informally affiliated with the Russian government or Russian business associates, which took place between June 16, 2015 and 12 p.m. on January 20, 2017, and associated records. Trump Organization attorneys became aware of the June 9 meeting no later than the first week of June 2017, when they began interviewing the meeting participants, and the Trump Organization attorneys provided the email setting up the meeting to the President's personal counsel. Mark Corallo, who had been hired as a spokesman for the President's personal legal team, recalled that he learned about the June 9 meeting around June 21 or 22, 2017. Priebus recalled learning about the June 9 meeting from Fox News host Sean Hannity in late June 2017. Priebus notified one of the President's personal attorneys, who told Priebus he was already working on it. By late June, several advisors recalled receiving media inquiries that could relate to the June 9 meeting. The President directs communications staff not to publicly disclose information about the June 9 meeting. Communications advisors Hope Hicks and Josh Raffel recalled discussing with Jared Kushner and Ivanka Trump that the emails were damaging and would inevitably be leaked. Hicks and Raffel advised that the best strategy was to proactively release the emails to the press. On or about June 22, 2017, Hicks attended a meeting at the White House residence with the President, Kushner, and Ivanka Trump. According to Hicks, Kushner said that he wanted to fill the President in on something that had been discovered in the documents he was about to provide to the congressional committees involving a meeting with him, Manafort, and Trump Jr. Kushner brought a folder of documents to the meeting and tried to show them to the President, but the President stopped Kushner and said he did not want to know about it, shutting the conversation down. On June 28, 2017, Hicks viewed the emails at Kushner's attorney's office. She recalled being shocked by the emails because they looked really bad. The next day, Hicks spoke privately with the President to mention her concern about the emails, which she understood were soon going to be shared with Congress. The President seemed upset because too many people knew about the emails, and he told Hicks that just one lawyer should deal with the matter. The President indicated that he did not think the emails would leak, but said they would leak if everyone had access to them. Later that day, Hicks, Kushner, and Ivanka Trump went together to talk to the President. Hicks recalled that Kushner told the President the June 9 meeting was not a big deal and was about Russian adoption, but that emails existed setting up the meeting. Hicks said she wanted to get in front of the story and have Trump Jr. release the emails as part of an interview with softball questions. The President said he did not want to know about it and they should not go to the press. Hicks warned the President that the emails were really bad and the story would be massive when it broke. But the President was insistent that he did not want to talk about it and said he did not want details. Sorry about that. Hicks recalled that the President asked Kushner when his document production was due. Kushner responded that it could be a couple of weeks, and the President said, then leave it alone. Hicks also recalled that the President said Kushner's attorney should give the emails to whomever he needed to give them to, but the President did not think they would be leaked to the press. Raphael later heard from Hicks that the President had directed the group not to be proactive in disclosing the emails because the President believed they would not leak. The President directs Trump Jr.'s response to press inquiries about the June 9 meeting. The following week, the President departed on an overseas trip to the G20 summit in Hamburg, Germany. accompanied by Hicks, Raphael, Kushner, and Ivanka Trump, among others. On July 7, 2017, while the president was overseas, Hicks and Raphael learned that the New York Times was working on a story about the June 9 meeting. The next day, Hicks told the president about the story and he directed her not to comment. Hicks thought the president's reaction was odd because he usually considered not responding to the press to be the ultimate sin. Later that day, Hicks and the president again spoke about the story. Hicks recalled that the president asked her what the meeting had been about, and she said that she had been told the meeting was about Russian adoption. The president responded, "Then just say that." On the flight home from the G20 on July 8, 2017, Hicks obtained a draft statement about the meeting to be released by Trump Jr. and brought it to the president. The draft statement began with a reference to the information that was offered by the Russians in setting up the meeting. "I was asked to have a meeting by an acquaintance I knew from the 2013 Miss Universe pageant with an individual who I was told might have information helpful to the campaign." Hicks again wanted to disclose the entire story, but the president directed that the statement not be issued because it said too much. The president told Hicks to say only that Trump Jr. took a brief meeting and it was about Russian adoption. After speaking with the president, Hicks texted Trump Jr. a revised statement on the June 9 meeting that read, "It was a short meeting. I asked Jared and Paul to stop by. We discussed a program about the adoption of Russian children that was active and popular with American families years ago and has since ended by the Russian government. But it was not a campaign issue at that time and there was no follow-up." Hicks' text included, "Are you okay with this?" attributed to you. Trump Jr. responded by text message that he wanted to add the word primarily before discussed, so that the statement would read, "We primarily discussed a program about the adoption of Russian children." Trump Jr. texted that he wanted that change because they started with some Hillary thing, which was BS, and some other nonsense, which we shot down fast. Hicks texted back, "I think that's right too, but boss man worries it invites a lot of questions. Ultimately defer to you and your attorney on that word, because I know it's important and I think the mention of a campaign issue adds something to it in case we have to go further." Trump Jr. responded, "If I don't have it in there, then it appears as though I'm lying later when they inevitably leak something." Trump Jr.'s statement, adding the word primarily and making other minor additions, was then provided to the New York Times. The full statement provided to the Times stated, "It was a short introductory meeting. I asked Jared and Paul to stop by. We primarily discussed a program about the adoption of Russian children that was active and popular with American families years ago and has since ended by the Russian government, but it was not a campaign issue at the time and there was no follow-up. I was asked to attend the meeting by an acquaintance, but was not told the name of the person I would be meeting with beforehand." The statement did not mention the offer of derogatory information about Clinton or any discussion of the Magnitsky Act or US sanctions, which were the principal subject of the meeting, as described in Volume 1, Section 4A5. A short while later, while still on Air Force One, Hicks learned that Priebus knew about the emails, which further convinced her that additional information about the June 9 meeting would leak, and the White House should be proactive and get on the front foot of the story, get in front of the story. Hicks recalled again going to the president to urge him that they should be fully transparent about the June 9 meeting, but he again said no, telling Hicks, "You've got a statement, we're done. You've given a statement, we're done." Later on the flight home, Hicks went to the president's cabin, where the president was on the phone with one of his personal attorneys. At one point, the president handed the phone to Hicks, and the attorney told Hicks that he had been working with Circa News on a separate story and that she should not talk to the New York Times. The media reports on the June 9, 2016 meeting. Before the president's flight home from the G20 landed, the New York Times published its story about the June 9, 2016 meeting. In addition to the statement from Trump Jr., the Times also quoted a statement from Carollo on behalf of the president's legal team suggesting that the meeting might have been set up by individuals working with the firm that produced the Steele reporting. Carollo also worked with Circa News on a story published an hour later that questioned whether Democratic operatives had arranged the June 9 meeting to create the appearance of improper connections between Russia and Trump family members. Hicks was upset about Carollo's public statement and called him that evening to say the president had not approved that statement. The next day, July 9, 2017, Hicks and the President called Corallo together, and the President criticised Corallo for the statement he had released. Corallo told the President the statement had been authorised and further observed that Trump Jr.'s statement was inaccurate and that a document existed that would contradict it. Corallo said that he purposely used the term document to refer to the emails setting up the June 9 meeting because he did not know what the President knew about the emails. Corallo recalled that when he referred to the document on the call with the President, Hicks responded that only a few people had access to it and said, "It will never get out." Corallo took contemporaneous notes of the call that day, also mentioned existence of Doc. Hope says only a few people have it, it will never get out. Hicks later told investigators that she had no memory of making that comment and had always believed the emails would eventually be leaked, but she might have been channeling the President on the phone call because it was clear to her throughout her conversations with the President that he did not think the emails would leak. On July 11, 2017, Trump Jr. posted redacted images of the emails setting up the June 9 meeting on Twitter. The New York Times reported that he did so after being told that the Times was about to publish the content of the emails. Later that day, the media reported that the President had been personally involved in preparing Trump Jr.'s initial statement to the New York Times that had claimed the meeting primarily concerned a program about the adoption of Russian children. Over the next several days, the President's personal counsel repeatedly and inaccurately denied that the President played any role in drafting Trump Jr.'s statement. After consulting with the President on the issue, White House Press Secretary Sarah Sanders told the media that the President certainly didn't dictate the statement, but that he weighed in, offered suggestion like any father would do. Several months later, the President's personal counsel stated in a private communication to the Special Counsel's office that the President dictated a short but accurate response to the New York Times article on behalf of his son, Donald Trump Jr. The President later told the press that it was irrelevant whether he dictated the statement and said it's a statement to the New York Times. It's not a statement to a high tribunal of judges. On July 12, 2017, the Special Counsel's office redacted Trump Jr. redaction related to the June 9 meeting and those who attended the June 9 meeting. On July 19, 2017, the President had his follow-up meeting with Lewandowski and then met with reporters for the New York Times. In addition to criticising Sessions in his Times interview, the President addressed the June 9, 2016 meeting and said he didn't know anything about the meeting at the time. The President added, "As I've said, most other people, when they call up and say, by the way, we have information on your opponent, I think most politicians, I was just with a lot of people, they said, who wouldn't have taken a meeting like that?" Analysis. In analysing the President's actions regarding the disclosure of information about the June 9 meeting, the following evidence is relevant to the elements of obstruction of justice. Obstructive act. On at least 3 occasions between June 29, 2017 and July 9, 2017, the President directed Hicks and others not to publicly disclose information about the June 9, 2016 meeting between senior campaign officials and a Russian attorney. On June 29, Hicks warned the President that the emails setting up the June 9 meeting were really bad and the story would be massive when it broke. But the President told her and Kushner to leave it alone. Early on July 8, after Hicks told the President the New York Times was working on a story about the June 9 meeting, the President directed her not to comment, even though Hicks said that the President usually considered not responding to the press to be the ultimate sin. Later that day, the President rejected Trump Jr.'s draft statement that would have acknowledged that the meeting was with an individual who I was told might have information helpful to the campaign. The President then dictated a statement to Hicks that said the meeting was about Russian adoption, which the President had twice been told was discussed at the meeting. The statement dictated by the President did not mention the offer of derogatory information about Clinton. Each of these efforts by the President involved his communications team and was directed at the press. They would amount to obstructive acts only if the President, by taking these actions, sought to withhold information from or mislead congressional investigators or the Special Counsel. On May 17, 2017, the President's campaign received a document request from SSCI that clearly covered the June 9 meeting and underlying emails. and those documents also plainly would have been relevant to the special counsel's investigation. But the evidence does not establish that the President took steps to prevent the emails or other information about the June 9 meeting from being provided to Congress or the special counsel. The series of discussions in which the President sought to limit access to the emails and prevent their public release occurred in the context of developing a press strategy. The only evidence we have of the President discussing the production of documents to Congress or the Special Counsel is the conversation on June 29, 2017, when Hicks recalled the President acknowledging that Kushner's attorney should provide emails related to the June 9 meeting to whomever he needed to give them to. We do not have evidence of what the President discussed with his own lawyers at that time. Nexus to an official proceeding. As described above, by the time the President's attempts to prevent the public release of the emails regarding the June 9 meeting, the existence of a grand jury investigation supervised by the Special Counsel was public knowledge, and the President had been told that the emails were responsive to congressional inquiries. To satisfy the nexus requirement, however, it would be necessary to show that preventing the release of the emails to the public would have the natural and probable effect of impeding the grand jury proceeding or congressional inquiries. As noted above, the evidence does not establish that the President sought to prevent disclosure of the emails in those official proceedings. Intent. The evidence establishes the President's substantial involvement in the communication strategy related to information about his campaign's connections to Russia and his desire to minimise public disclosures about those connections. The President became aware of the emails no later than June 29, 2017, when he discussed them with Hicks and Kushner, and he could have been aware of them as early as June 2, 2017, when lawyers for the Trump Organization began interviewing witnesses who participated in the June 9 meeting. The President thereafter repeatedly rejected the advice of Hicks and other staffers to publicly release information about the June 9 meeting. The President expressed concern that multiple people had access to the emails and instructed Hicks that only one lawyer should deal with the matter. The President dictated a statement to be released by Trump Jr. in response to the first press accounts of the June 9 meeting that said the meeting was about adoption. But as described above, the evidence does not establish that the President intended to prevent the Special Counsel's office or Congress from obtaining the emails setting up the June 9 meeting or other information about that meeting. The statement recorded by Corallo that the emails will never get out can be explained as reflecting a belief that the emails would not be made public if the President's press strategy were followed, even if the emails were provided to Congress and the Special Counsel. And that is the end of that section. We'll move on to the President's further efforts to have Attorney General take over the investigation. We'll leave that to our next recording.